Welcome to the continuing professional development model on tenant relationship and the law. Today we're going to conduct a whistle-stop tour of landlord-tenant law, and hopefully we're going to light your candle insofar as the aspects of that law is concerned. The contents of the presentation today are really broken up into four parts. We're going to begin with some introductory comments. We're then going to move on to the South African rental law framework, and then we're going to essentially move to what I describe as the tectonic plate of landlord-tenant relationships, and that is the Rental Housing Amendment Act and the Rental Housing Amendment Act of 2014. Once we've done that, we'll then just finish off with some concluding remarks. The purpose of this module is to provide both estate agents and managing agents with the necessary knowledge about South African rental housing law, particularly the Rental Housing Act, otherwise known as the RHA. Now, you might ask, why is this important for managing agents and for estate agents? Well, the first thing is that the Rental Housing Act defines a landlord to include the landlord's duly authorized agent. And clearly, as a managing agent, you would be a duly authorized agent of a landlord. You might also have to appear before the rental housing tribunals, which you're going to talk about that later, and therefore it will be helpful to have some knowledge of that tribunal and what might be expected of you there. And then, of course, it's also important that you would know what the obligations of and rights of landlords and tenants are. Just a brief comment around the status of the Rental Housing Amendment Act. The Act has been published by the state president and is due to come into operation on a date to be determined by the state president. That date has not yet been determined, but we are hopeful that it will come into operation during the course of this year. In short, rental housing law is a set of legal rules that regulate the landlord-tenant relationship. Turning then to the South African rental housing law framework. The purpose of this particular section is to provide an overview of the laws governing rental housing in South Africa. In South Africa, the relationship between a landlord and tenant is governed by a lease agreement that is regulated by legislation. The common law gives the landlord and tenant the freedom to determine the context of their relationship, and the legislation limits certain rights of the parties in terms of what they can or cannot agree. In essence, what legislation does is it provides the minimum standards for which a landlord and a tenant must abide. We then turn to the statutes that govern the South African rental housing law framework. Well, we start, of course, with the Constitution of the Republic of South Africa. The right to housing is a fundamental right in the Constitution, with particular reference to Section 26. Section 26(1) gives to everyone the right to have access to housing. Section 26(2) requires the state to take legislative and reasonable measures to enhance the right of access to housing. And particularly for our purpose, 26(3) of the Constitution specifically provides that no one may be evicted from their home without first having obtained a court order. Turning then to the second piece of legislation, which is the Prevention of Illegal Eviction Act, that's otherwise known as the PI Act. Simply what that does is that imposes certain requirements that must be followed when evicting a tenant. That's all you need to know for current purpose. Leave the rest to the lawyers. We then turn to the third piece of legislation, which is the Consumer Protection Act. The Consumer Protection Act requires documents to be interpreted to the benefit of a consumer. It requires documents to be written in plain and understandable language. So this means that lease agreements must be written, as is said, in plain and understandable language. Insofar as there might be a dispute between the Consumer Protection Act and the Rental Housing Act, which we will talk about later. What I would like to say to you at this stage is simply refer that dispute to the rental housing tribunals to provide clarity in that regard. We then move to what I describe as the tectonic plate of South African rental housing law, and that's the Rental Housing Act. That legislation came into operation in 2000. It is one of the legislative measures that government has taken to achieve the realization of the right to act of access to housing. But more of that later. You would also need to be aware that there is sectional title legislation that does impact on the rental, on the landlord-tenant rental housing legislation. In that regard, I just refer you to the Sectional Titles Act and the Sectional Title Schemes Management Act. But I specifically refer you to the Community Schemes Ombud Service Act. Now, what is that legislation, you might ask? Well, its purpose is to provide for a dispute resolution mechanism for disputes in community schemes. Community schemes covers the usual sectional title complexes, retirement villages, golf estates, and home ownership associations. Now, it's not impossible that you might have a relationship where the owner of one of the units in the golf estate or sectional title scheme lets out that property to a tenant. Now, a tenant who legally resides in a private area in a community scheme is deemed to be an occupier and may approach the Ombud to resolve a dispute falling within the administration of the body corporate or the homeowners association. However, a dispute between the tenant and the owner of the section regarding the payment of rental must be referred to the Rental Housing Tribunal. Turning then to the tectonic plate, and that's the Rental Housing Act as amended by the 2014 Amendment Act. We're going to discuss, we'll start off with a slight overview of that legislation. We'll then go on and look at important terms. We'll look particularly at rights and obligations of landlords and tenants. We'll look at lease agreements, what the Rental Housing Tribunal is all about, its dispute resolution procedures, rental determination, regulations, offences and penalties. We'll briefly look at appeals and reviews, and then we'll look at the general provisions. Beginning then with the overview. The primary purpose of the Rental Housing Act is to stabilise and regulate the residential rental housing sector by the establishment of the rental housing tribunals in each province to settle disputes between landlords and tenants. And this is significant because what it does is it takes disputes out of the courts, and landlords and tenants need no longer approach courts, which is time-consuming and expensive to have their disputes resolved, because they can approach the rental housing tribunals at no cost. The second purpose of the Rental Housing Act is to provide for regulations, and more specifically the unfair practices regulations. Now, it's important to note that the Rental Housing Act applies to all residential tenants and landlords in South Africa. That includes government and parastatals. So in short, no one is excluded from the provisions of that Act. The rental housing tribunals deal with issues of lawful and fairness when determining the unfair practices, which are effectively the do's and don'ts for tenants and landlords. And by lawfulness and fairness, the courts simply look at what is law and what is lawful, whereas the rental housing tribunals look at the wider issues of lawfulness and fairness. Turning then to the important terms in the Rental Housing Act. And it is important for managing agents and estate agents to be aware that a dwelling is defined very, very widely to include a house, a hut, a shack, a room, an apartment, an outbuilding, a garage, a storeroom, a demarcated parking space, which have been leased as part of a lease. So it is very, very wide indeed. The unfair practice is defined as any act or omission by a landlord or tenant that violates the Act or the Unfair Practices Regulations. So effectively, a failure to comply with the Act, a failure to comply with the Unfair Practices Regulations can in itself amount to an unfair practice. And then what we also just need to be aware is that a tenant is very widely defined to simply mean a lessee of a dwelling. The 2014 Amendment Act has a social conscience to it. It introduces the concepts of habitability and habitable, which effectively have the same meaning, and they mean a dwelling that is safe and suitable for living in. So essentially what the legislation is trying to say here is that no longer can you let out a dwelling that is in a poor living condition. Linked to that is the additional term that the 2014 Amendment Act introduces, and that's the terms of maintenance and maintain. And that refers to the repairs and upkeep required to ensure that the dwelling remains in a habitable condition. So we see what the 2014 Amendment Act is beginning to do, is it's beginning to talk to the quality of dwellings that are leased. So we now turn to the rights and obligations of tenants and landlords. And there are a number of them. Let's deal firstly with the issue of discrimination. A landlord may not discriminate against a tenant on any of the grounds set out in the Constitution. We all know those to be, whether it be age, sex, race, sexual preference, pregnancy, and those sorts of things. You cannot discriminate against a tenant on those grounds. The Rental Housing Act gives to the tenant the right to privacy. It also gives that right to the tenant's visitors. And what it means is that that the tenant may not have his or her home or person or property searched or seized without a court order. They also cannot have their communications infringed. So, for example, no longer can a landlord simply take the post that is delivered to a tenant and then ensure that the tenant doesn't get it. That becomes effectively an unfair practice. The Rental Housing Act also gives to the landlord the right to receive the rental and to recover that rental. So there's clearly an obligation then on the tenant to pay the rental timelessly and to pay the correct amount. The lease may also be terminated on grounds set out in the lease. And in most instances, this is going to relate to issues of non-payment of rental and issues such as nuisances. By nuisances, we mean noise in the dwelling which may be inconvenient to other tenants. The tenant must return the dwelling in the condition in which he received it, fair wear and tear accepted. Well, and what do we mean by fair wear and tear? Well, the first thing is we've just got to adopt a reasonable approach to that. And by reasonableness, we would mean what would the average reasonable person or tenant have done when they lived in that unit. So the general rule is that if the tenant damages the dwelling, then one simply has to ask, was this damage caused normally in the course of living in that dwelling? And if the answer to that is yes, then that simply becomes fair wear and tear. The landlord can also claim compensation for the damage caused to the dwelling. And these are all very, very important and significant rights for the landlords that you, as the managing agent, would want to know about, because as we're going to see later on, the Rental Housing Tribunal is there to determine these kinds of disputes. A very important issue that the tenants and landlords need to be aware of is that a landlord is obliged to provide written receipts for any amounts of money that have been paid by the tenant to the landlord, whether it be in respect of rent, deposits, or utilities. The tenant must be given a receipt setting out the tenant's name, the amount, and what the amounts comprise of. Let's talk a little bit about deposits. The important thing to note is that a deposit is not money that belongs to the landlord. It is money that is paid over to a landlord, and is to be held in a trust account or in an interest-bearing account with a financial institution at an interest rate of no less than a savings account. So clearly what the Act is saying is that a landlord can require a deposit to be paid. We know that that is the practice in the industry. The Act does not set out maximum amounts for deposits. That is simply left to the landlord and the tenant to agree upon. At the beginning of the lease, it is an obligation on both the landlord and the tenant to jointly inspect the dwelling before the tenant moves into the dwelling. Similarly, at the end of the lease, and no more than 3 days before the end of the lease, once again, the landlord and the tenant must jointly inspect the dwelling, and the purpose of that is to determine the condition of the dwelling at the beginning of the lease and at the end of the lease. And that then has the secondary purpose to determine whether or not damage has been caused to the dwelling during the period of the lease. It is absolutely important to conduct the inspections, because a failure to conduct the inspection will result in the premises being deemed to be in a good condition. So it's very, very important, no matter how busy a managing agent may be, and it does not matter whether one is working in a very, very big letting institution, the inspections must take place, because a failure to do that could result in the premises being deemed to be in a good condition, when in effect there may have been serious damage having been done to the dwelling during the period of the lease. At the end of the lease, the deposit, less any damages, must be refunded to the tenant. And the Act sets out a series of time periods for that to happen, and I'll just alert you to those time periods which are in the Act. A landlord may not seize the property of a tenant either without an order of the court or without having obtained a ruling of the tribunal. Turning then to costs of the lease, one can only claim the actual costs incurred in the lease. So effectively what that is saying is that if they are just simply standard fees that are applied for the purposes of a lease, that would be contrary to the Act. We've already seen that you cannot lock out, you cannot evict, and you cannot cut off utilities without an order of the court. So what we're already beginning to see is that lockouts, cutting off of utilities, evicting tenants are no-nos without an order of the court. Turning then to the 2014 Amendment Act, we've already seen the introduction of the concepts of habitability and maintenance, and landlords are now clearly required to let out dwellings that are both habitable and to maintain the dwelling during the period of the lease as set out in the lease itself. The 2014 Amendment Act also introduces an interesting obligation on the landlord, and that is in terms of basic services. The landlord must, where possible, facilitate the provision of basic services to the dwelling. And I think what the legislature there is looking at is simply to say that effectively where poorer communities do not have access to basic services such as water and electricity, that a landlord must try and facilitate the provision of those services, not provide them. The 2014 Amendment Act also adds in an additional obligation on the landlord to protect the privacy of the tenant by ensuring that inspections are done in a reasonable time and in a reasonable manner and upon reasonable notice to the tenant. And then it also says that subletting may not be unreasonably withheld, and therefore implied in that is that you may have a landlord who lets a property or a dwelling to a tenant, and that the tenant in turn may sublet that property to another tenant. And what the Amendment Act is saying is that it acknowledges that practice exists, but it must be done with the consent of the landlord, who cannot withhold that consent. So we now turn to leases, and there's a tectonic shift here. The Rental Housing Amendment Act doesn't provide that lease agreements must be written. The only exception is that they must be written if the tenant requests the landlord to reduce the lease agreement to writing. However, the 2014 Amendment Act changes the ball game in that regard. Lease agreements now have to be written, and there are about 8 sets of information that the lease agreement needs to provide for. And we set them out. It's being set out the name of the tenant and the landlord, the description of the dwelling, the amount of rental and escalation, if any other changes in addition, charges in addition to the rental, the frequency of the rental payments. Is it monthly? Is it weekly? How often do we need to pay? The amount of the deposit, if in fact is a deposit to be paid. The lease period, is it on a monthly basis? Is it for a year? Is it for 2 years? Set that out. And if there's no lease period set out, then at the very least you've got to set out the notice period required to terminate the lease agreement. And then, of course, it's got to set out the obligations of the tenant and the landlord. We've already looked at those. Those are going to need to be incorporated into the lease agreement. What is also interesting is that the 2014 Amendment Act now requires the Minister of Human Settlements to draw up a pro forma lease agreement in all of the 11 official languages. This is an important intervention. It's there to empower tenants who are not conversant in English and Afrikaans. It will hopefully then enable them to enforce their rights, but more significantly also know what their obligations are. We spoke earlier on about the inspection of the dwelling at the beginning and at the end of the lease. A defects list is to be drawn up, reflecting what the defects are, if any. And then that defects list must be attached to the lease. And that is so even if there are no defects recorded. The list will simply be attached to the lease, recording that there are no such defects. And then significantly, as I've already alluded to, is that lease agreements are enforced either through the rental housing tribunals or through a competent court. And that then takes us into the rental housing tribunals themselves. The establishment under the Rental Housing Act of rental housing tribunals is discretionary. All provinces, except for the Free State, have established a tribunal. The tribunals consist of a minimum of 3 and a maximum of 5 members, which include a chairperson and a deputy chairperson. The quorum of the tribunal is always 3. By that we mean any decision handed down by the tribunal must have been made by 3 members. Importantly, the Rental Housing Tribunal is independent and it is impartial. It does not therefore favour either a landlord or a tenant. Its decisions are taken by consensus, failing which a decision of the majority of the members applies. The 2014 Amendment Act introduces some very big changes. First of all, it deals with the failure of the Free State Province to establish a tribunal by now making it obligatory on the MEC to establish a tribunal in his or her province. The tribunals have experienced exponential growth over the last 10 years. To deal with the backlogs and to expedite the resolution of disputes, the composition of the tribunal is now increased to 7 members. Significantly, it now provides for the tribunal to have 2 meetings or hearings simultaneously. So, for example, what it would mean is that a tribunal can sit in Pretoria and in Johannesburg on the same days. It can sit in Cape Town and in Somerset West or in George on the same day, Pietermaritzburg and Durban on the same day. And the wonderful benefit of this is that it is envisaged that the tribunals are going to be able to increase their output in the resolution of disputes by 100%. The decisions around consensus and the majority decision applying remain under the 2014 Amendment Act. So we then deal with dispute resolution by the tribunal. The Rental Housing Act simply applies or requires a complaint to be lodged in the prescribed form by a landlord or a tenant who wishes to lodge the complaint. It is significant that the dispute resolution services of the tribunal are free of charge, and that is a massive contribution by the state towards both landlords and tenants. How does the tribunal resolve disputes? It does so in three ways. A dispute can be resolved informally and by agreement between the parties. How might that work? So let's take, for example, a tenant lodges a complaint because they've been locked out without an order of court. The member of the office of the tribunal, but not the tribunal members, would telephone the landlord and draw this to the attention of the landlord. The landlord might acknowledge that he or she does not have a court order, and it would then be agreed that the tenant would be reinstated. The matter is resolved by agreement between the parties. Secondly, the tribunal offers mediation resolution facilities. And that's really where an independent third party known as the mediator would sit the parties around a table, and the landlord and the tenant would be able to discuss their dispute, and the mediator would use his or her skills as a mediator to bring the parties to a resolution. However, not all mediations result in an agreement, and in that instance, the matter is then referred to a full hearing to be adjudicated by the tribunal. The tribunal has very broad powers to make rulings. It can compel any person to stop an unfair practice. It can order a landlord who's locked a tenant out of a dwelling without a court order to allow the tenant back into the dwelling. And you've probably heard of a spoliation order. That's an example of a spoliation order. In addition, the tribunal can order a landlord who has shut off the utilities, that's the water, the gas, the electricity supply, without an order of court, to restore the supply. It can also make an order for a landlord to attach property where the tenant has not paid the rental or any other amounts. Similarly, it can also make an order for the tenant to attach some of the landlord's property in the event of a landlord having failed to refund the deposit. It can grant interdicts. What's an interdict? That's an order that prohibits a tenant or a landlord from certain behavior or actions. So, for example, the landlord may say, if you don't pay the rent by X date, I'm going to lock you out. The tenant can then approach the tribunal for an order interdicting the landlord from locking the tenant out. Similarly, if a tenant continually causes nuisances and noise through large parties every night at 12 o'clock, a landlord can approach the tribunal to order the tenant to desist from such behavior. Let's talk a little bit about settlement agreements that have been concluded at mediation rulings. The parties at mediation, when they conclude their agreement, can include a clause in that settlement agreement that their agreement is to be made a ruling of the tribunal. That settlement agreement would then be placed before the tribunal in its chambers, and the tribunal would then, having applied its mind, then make that an order of the tribunal. This is significant, and it is significant because we will see later that tribunal orders are deemed to be orders of the magistrate's court. And so the benefit of reaching an agreement at mediation and then having it made an order of the tribunal would mean that a landlord or a tenant, at no cost, without even going before the tribunal, would have the equivalent of a court order. A massive intervention and benefit for both landlords and tenants. The tribunals have inspectors. Their duties are quite wide-ranging. They inspect buildings, they provide written reports, and the tribunal can order those inspectors to appear before the tribunal and to talk to the inspection reports. It can summon landlords, tenants, or any other persons to provide evidence and to present documents to the tribunal. And the tribunal can, in appropriate instances, make costs orders. The general policy is not to make costs orders, but in the event of seriously bad behaviour, the tribunals have been known from time to time to make an order of costs against a landlord or a tenant. The 2014 Amendment Act clarifies that the tribunal has the powers to make orders for payment of rental. There had been some dispute around it, but clearly, from a managing agent's point of view, if your client, the landlord, has rental outstanding, approach the tribunal and they will make those orders for payment of rental. There's always been much debate around the eviction powers. It is now settled law that tribunals may not make orders for eviction. That must be left to a competent court in terms of the Constitution, as we've seen earlier. Sometimes the tribunal might make rulings in the absence of a party who, for some reason, good reason, has not been able to be present. The 2014 Amendment Act empowers the tribunal to rescind or vary an order of its rulings subject to certain conditions. Just important that you know that that power exists. And we've already spoken about the enforceability of tribunal rulings through the magistrate's court, because they are deemed to be orders of the magistrate's court. And you simply enforce the order by following the procedures set out in the magistrate's court. Briefly, let's deal with rent determinations. It was often thought that with the introduction of the Rental Housing Act that the tribunals were not empowered to make rent determinations. They are, but subject to certain limited conditions. The tribunal, when making a ruling, may make a rental determination. What that means is you cannot just approach the tribunal for a rental determination. It must be linked to some other unfair practice, i.e. offence, and the intention to enforce a right. And simply what the Act says there is that there are a range of considerations the tribunal must take into account. So, for example, prevailing economic conditions of supply and demand, looking at the market, the landlord's need for a realistic return on investment, and certain measures that the minister may have introduced into the rental housing policy framework. All the 2014 Amendment Act does is it says, and when considering that first consideration, you no longer take into account supply and demand. You've simply got to look at the prevailing economic conditions. And the thinking behind that is that where there's a shortage of accommodation, then the rental is increased. And simply what they're wanting to say that always means that a tenant would be on the back foot insofar as rental increases are concerned. And they're saying, yes, you can continue to increase, but just simply look at what the prevailing economic conditions are and not limit it to supply and demand. You might ask, what are rental housing information offices? Well, the purpose of a rental housing information office is that they be established in a local municipality, and they're there to advise landlords and tenants of their rights and obligations. The 2014 Amendment Act said that the establishment of an information office by a local municipality was discretionary. There was much debate around that because the municipalities would often be saying, we don't have the resources and we don't have the money to establish the information offices. The 2014 Amendment Act now clarifies that. It says that the municipalities will establish an information office. So what we're going to see is that across the municipalities in South Africa, rental housing information offices are going to come into operation. It's a welcome development, and what it means is that landlords and tenants, even if they don't live in the big cities, they've got a dispute around what they believe to be a landlord-tenant dispute, and they can simply go down to the local information office within their municipality and seek advice concerning their rights and their obligations. Briefly then turning to regulations. Under the Rental Housing Act, the MEC for human settlements or housing in the provinces was given the right to make regulations. The 2014 Amendment Act changes that, and it gives that power to the minister. And the purpose behind that is to have one set of national regulations that apply equally across the country and to bring about uniformity of outcomes. There are essentially two types of regulations. The smaller set really are the procedural regulations, and they really relate to the way the tribunal goes about its business. What are the procedures that it should follow? What are the notices that it should give when performing its functions, its powers, its duties? And it also sets out the functions, powers, and duties of inspectors. We've already referred to the unfair practices regulations along the way. Well, you might want to ask, really, what are they? The Rental Housing Act provides that the rental housing sector is to be regulated through the unfair practice regulations. We've already seen that an unfair practice is a breach of the Rental Housing Act or the unfair practices regulations. The unfair practices regulations prescribe unfair practices that are not provided for in the Rental Housing Act. So the Act will set out the broad parameters, the rights and obligations. What then happens is that the minister, by way of the unfair practices regulations, will then add further obligations and rights of landlords and tenants. In other words, setting out more of the do's and the don'ts for landlords and tenants. And that can be in relation to lease agreements, changing of locks, deposits, maintenance damage to property, unlawful evictions, utility services, non-payment of rental, nuisances, forced entry, and obstruction of entry, and the like. Turning then very briefly, any legislation has offences and penalties. And this is important for managing agents because they need to be advising their clients what will happen if you don't follow the do's and the don'ts. So if you are summoned to appear before the tribunal and you don't, that could result in a criminal conviction. If you don't provide materials that are requested or you provide false materials, that can result in an offence. If the tribunal says we want you to do the following things and you don't do it in terms of its ruling, well, then that can be an offence. To evict, cut off services can be an offence, and also to contravene any regulation. In addition, the 2014 Act, because it now provides that all leases must be reduced to writing, makes it an offence not to reduce a lease to writing. Interfere with the rights and obligations of a tenant and a landlord, that can be an offence. And if you don't refund a deposit when you should do in terms of the legislation, then that can be an offence. And if you are prosecuted in a criminal court for that, then you can be sentenced to a fine or an imprisonment, or to both such fine and such imprisonment. Very briefly, appeals and reviews. An appeal in the wide sense is a rehearing of the entire matter. In the narrow sense, an appeal is just simply a hearing on the actual merits, i.e. on the facts of the matter, but it's limited to what took place at the original hearing. A review really is a very limited rehearing to determine whether the person who heard the case acted properly and honestly. The Rental Housing Act says that you can take a decision of the Rental Housing Tribunal on review. So that was simply whether or not one acted properly or honestly in the handing down of the decision. Generally, did you follow the right procedures? If yes, then effectively the review would not succeed. What this 2014 Amendment Act does is it introduces an internal appeal procedure inside the tribunal, and it then allows that the appeal decision to be taken on review in the High Court. So what we still see is that effectively, internal to the tribunal, you can appeal looking at the merits. External to the tribunal, you can only review in the High Court to decide whether or not the person who made the decision was acted honestly and properly. Just dealing very briefly with what I call the potpourri or the general provisions, the Act changes the word landlord to landowner in the legislation. Whether we're now going to be talking about landowner-tenant relations is another thing, but that's what the legislation seeks to do. And it also says that once the 2014 Amendment Act comes into operation, landlords and tenants, and therefore managing agents, will have 6 months from the date that it's published to ensure that it begins to comply with the provisions of the Rental Housing Amendment Act. And so as we then move towards our conclusion, the tribunals, especially in the last decade, and the 3 largest provinces have experienced exponential growth in the last decade. I want to suggest to you today that the 2014 Amendment Act amendments are far-reaching. They have the potential to materially affect the provision of rental housing, the management of multi-tenanted buildings, and to reduce tensions between landlords and tenants. And so what I want to say is that it's important for managing agents to begin planning to implement those amendments. It's important that you let your candle shine brightly and ensure that the obligations and the rights set out in that legislation are complied with by your clients. Thank you very much. This brings me to the conclusion of the presentation. Please remember to answer the 10 multiple choice questions to obtain your 5 verifiable CBD points for this session.